All right, next on the docket, the police shooting of Walter Scott in South Carolina. Prosecutors say that they will retry former officer Michael Slager. That after a mistrial was declared when one single juror, would not agree to convict.
Court therefore must declare a mistrial in this case.
After 4 days of deliberation in this racially divisive case, jurors deadlocked over murder and manslaughter charges. The mistrial means that this former North Charleston police officer will wake up in his own bed today, but still under house arrest and wearing a GPS device on his ankle.
Until my family can see justice, no, there's no forgiveness.
The only black juror, who was also the foreman, told the judge they just couldn't agree on a decision. Two of the women on the jury cried.
And that's the way our system works.
In a statement this morning, the prosecutor says, "We will try Michael Slager again." The mother of Walter Scott, who was on a phone call with her son when he was killed, silently raised her hands in court, praying for strength.
I don't care what man say. I don't care how it looks. It's not over. Y'all hear me? It's not over. So God say it's over.
The man many think is the lone holdout juror who wrote to the judge that he couldn't in good conscience convict this police officer did not look the judge, the lawyers, or the Scott family in the eye.
I'm sure we'll quickly hear from the rest of the jurors who disagree with him, what he was saying.
Michael Slager is seen in the cell video shooting Scott 5 times in the back as he was running away. When he fired the first bullet, Scott had already run 18 feet. But Slager says what the video doesn't show is the fight that happened just before. In court, he told jurors that at the time, when he started shooting, he thought Scott was a threat.
I fired until the threat was stopped, like I'm trying to do.
All right. There's some mechanical questions of this case that I want to get to. But first, jury selection. Obviously, a racially charged case. Did the prosecution pick the right pool if you have 11 whites and 1 black in a racially charged case in South Carolina?
Well, it's difficult to say because it depends on who you have and what the answers are of the people that are selected in the veneer. So if you end up with a panel of, say, 80 people, you may have, let's say, 20% black. But if you don't get to those people, first of all, they may be, sprinkled throughout the 70s. Some of them may make statements that they can't be fair because they're concerned about police shootings. Then you get people perhaps like this person.
My point is, Mayo, clearly there was a racial component to this case. It certainly seems on the surface. And to have less than 8% of the jury be of the color of the person that was killed, to me, either the prosecution dropped the ball here or they thought it was such a slam dunk here, well, the race was irrelevant.
It's not, but it's not always, you don't always get to pick who the first 12 are that you're going to end up with. But also, you got to look here that 11, or certainly 10, presumably 10 white jurors had no question whatsoever and were very willing to find him guilty. That makes this case a bit less racially divisive because the other jurors had no problem finding that, that he was wrong.
Let me ask you, though, Doug, you got a trial. And you go through, obviously, jury selection and all the rest. Somebody gets through, okay? I don't care, white, black, purple, green, makes no difference to me. Somebody that's clearly not following the letter of the law or making up their own facts to go on, or bring their own baggage into the court, into the courtroom or the deliberations room. At what point do they say, wait a minute, this person's not interested in the pursuit of justice. Let's bounce this guy and get somebody. How high a threshold is it to say, this guy has no interest in the facts of what was presented?
Well, Rich, what you have to realize is that you have these jurors that come in off the street because we want people in the jury that have life experience.
A jury of our peers.
A jury of our peers. We want people that have their life experience. We don't ask people to, check at the door everything they've ever known in their life. We want these people with life experience. These the process of picking a jury often takes days, weeks, it could take months with complicated cases because you want to weed out the people that have, their biases are so strong that they can't listen to the evidence. I
appreciate that, Doug, but my question to you is, now you go through it and somebody slips through. Okay? And now they're in the deliberation phase. I'm trying to understand, as the layperson here, what's the standard between somebody that, you know, is bringing their life experience that we may not like to somebody who's just not following the facts of the case?
Well, here's the deal. Every juror is supposed to deliberate with the other jurors. They're supposed to listen to the other jurors. Everybody's supposed to give their opinion. When you said somebody slips through, that means the system has just broken. Nobody's supposed to slip through. You're supposed to be vetted for
Well,
your
you can
biases.
mislead the attorneys as to how unbiased you'll
People
be.
do slip.
Well,
people do slip
if they slip through and you're misleading, you're sworn as a juror to tell the truth.
So I'm going to have a hypothetical. I'm in now in the deliberations room, and I say to the rest of my peers, I don't care what he did. A cop's a cop, and a cop can't do any wrong in my eyes.
Report it, and that's a guy that can get bounced.
Okay.
The
And
answer
clearly,
to your question
reportedly,
is,
that didn't happen. So I'm
Right.
just, where's that line, Jimmy? Is it a gray area or is it black and
it's
white?
not. Well, it's a gray area because it's very, very difficult to bounce a juror. But if a juror refuses to deliberate, if a juror outwardly refuses to follow the law as it's given to him or her, then a note from the foreman should come through. We have a juror that refuses to deliberate, refuses to even talk to us, refuses to consider the facts, basically refuses to deliberate because that person is not going to convict a police officer.
I got to think
At
that's
that
huge
point-
grounds for appeal if
Well,
I'm now the defense to say,
well,
wait a
no,
minute.
You're not winning that appeal because what will happen is the judge will then bring the juror out and speak to the juror. And if the juror confirms it well
Yep.
enough, then that juror can be bounced, and that's what alternates are for.
Got it.
An alternate
Right.
is
I
brought in.
want to not lose my time, Mayo. I have another question. Again, the mechanics of this. So not once, not twice, at least 3 times, the judge sent the jury back to deliberate because, and they made it clear, including a letter from the holdout juror who said, there's no way that I'm going to be able to convict this officer. Now, let me take the opposite point of view. I'm the defense attorney. There's been 3 times where my guy should be getting off, and you, the judge, are disregarding what the jury's saying. And then on Friday, he says, go home over the weekend. I'm not sequestering you. You go home. Now, again, all 3 of you have been in more courtrooms, hopefully, than I'll ever see in, in 1 week. You've seen more than I have. But I got to think the message is, go home and listen to what's going on and what people are saying here, and maybe your conscience will kick in. If I'm the defense attorney, I'm freaking out at this point to say, wait a minute, we went through a trial. We're playing by the same sets of rules as you are. You're trying to direct a verdict here
Welcome
from
to our world.
You're absolutely correct. And if I'm on the defense there, I say, well, look, how much more unequivocal does this guy have to be? He's already said crystal clear no. And then if he comes back and everybody browbeats him into eventually following their viewpoint, which does not necessarily mean proper deliberation either.
Yep.
You have a right to maintain your view of the case. Just because 11 people are against you doesn't mean you have to all of a sudden convert to them. And so your word is equal to each of them. At that point, I'd say, well, are we really getting a verdict based on the merits of the case, or did we just kind of browbeat this person
If he changed his mind over the weekend, would there have been justifiable grounds for an appeal or no? Wow. Okay. Now, guys, and I want to get to the big question in a second, but
Well,
when
it
the
depends on
process...
what the judge said to him, but
Yes,
usually
that's
not.
true.
But do we still think, and I know you guys got a vested interest in this as the defense attorneys and stuff, but do we still think that, like, this is a perfect example? 11 out of 12 see everything the rest of us see in color video. A guy running away with nothing on. And by the way, what we don't even show is after he shot, the officer then comes over and drops something which clearly looks like it's a plant. And he had no rationale when questioned by the prosecution why he would walk over and drop what was then the taser. He even maintained he thinks he had his taser. That certainly wasn't a life-threatening event. So anyway, my point is, do we still think
Are you upset?
we
about
need
this?
12 out of 12 is enough?
Yes.
Or is 11 out of 12 ever good enough?
No.
I think that the bigger issue here really is that we give a presumption to law enforcement, where the presumption should go to the accused. In this case, the accused happened to be law enforcement, but he still is a police officer. As a police officer, he's going to really kind of balance it out because of his career. But if there was no video, there would have been no charges. They would have simply adopted whatever the officer said. His fellow officers were happy to go along with that, by the way, also. One of them was an African-American police officer.
But by
So-
the way, let's be fair to the police department. Unlike in a lot of cases, they immediately, when this video came out, they cut him loose, they fired him. The police chief, and it was extremely critical of his action, said he couldn't stand with it. Well, apparently one juror didn't see
Well,
it
Rich,
that way.
your question about the 12
Yeah.
out of 12 civil cases, you don't. It could be 6 jurors sometimes, depending on the state you're in. 6 could be 12. You don't need, it doesn't have to be
You don't
unanimous
need
in certain jurisdictions.
unanimity.
Yeah, in certain
Okay.
jurisdictions.
Hey, Richie, you had one juror here who was never going to convict the cop. He held it. He slipped through, as Doug
Okay,
said.
but now the final question, because I got no time, Jimmy. Mayo's already said it. There's a presumption out there. And to me, we can debate the Michael Brown case. I mean, to me, what Michael Brown did when he reached into the squad car, started beating up the cop, and how that went down, people can debate this one,
Right.
but it's debatable. To me, this isn't debatable. But the common ending of an officer getting away with the shooting, and, today, 2 more cops were shot, okay? So this doesn't happen in a vacuum. You don't have to remind me about Dallas. But it's almost like the worst offenders, because they get off, paints a whole stigma, and a wrong one, on the men and women in blue that in the vast, vast majority would never even think of doing something like that. But then people ask the question, what does it take to convict an officer who does something so wrong? Are they right?
In my view, in this case, it takes another trial. The evidence is so clear-cut in this case.
Better hope it doesn't end the same
It's
way.
so clear-cut. But it is difficult to convict a police officer when you have competing stories because, fortunately or unfortunately, people tend to believe the
And Mayo,
police officer.
you look at the Leanne case, right?
Right.
Nobody tells me he went into that stairwell to kill anybody. A terrible ricochet, and poor Kai Gurley did nothing wrong, is dead as a result. At least he was convicted for that, and that was far less egregious than what I've just seen in color video.
And if a Kai Gurley was in that same hallway and was scared and a bullet ricocheted off and shot Officer Liang, he would be in jail right now.
All right.
He's right.
I don't have consensus on this one, but this case to me, in a million years, I never thought anybody could have seen it other than what it was, and that was criminal. All right, coming up next. Remember the stand your ground law in Florida and how that was constantly talked about when George Zimmerman was acquitted for the killing of Trayvon Martin? Well, now it's back, and it could be a factor in the killing of a former NFL player, a former New York Jet, who was killed in broad daylight in Louisiana.